Chapter 4. Transfer of Beneficiary's Interest. Key exam issues. When answering questions concerning the alienation of the beneficiary's interest, consider generally 1. Whether the interest is assignable voluntarily or reachable by creditors. Remember that a beneficial interest is freely alienable unless there is a valid trust provision to the contrary. And 2. What effect the assignment or attachment will have. This issue is likely to involve the exact nature of rights assigned or reached, and may include priority questions. Specifically, when creditors are involved, think about the following. 1. Whether creditors can reach a beneficial interest or assets subject to a power, e.g., of revocation, depends upon whether the debtor is the settlor or merely a beneficiary. This may also be relevant in determining the effect of a spendthrift restraint. 2. Spendthrift trusts should be examined in terms of possible exceptions for special claimants. Roman 2. Any local statutory limits. And Roman 3. Fundamental validity under local views of public policy. A. Alienability of beneficiary's interest. 1. Right to transfer in general. 441. Beneficial interests in a trust are freely alienable by the beneficiaries, unless there is a valid provision to the contrary in the trust instrument. Thus, a beneficiary can assign, pledge, or encumber her interest, or even transfer it in trust for another. Also, if the interest is not conditioned on the beneficiary's survival, it will pass by will or by intestate succession. Rest. 3D 51. A. Rationale. The beneficiaries are equitable owners of the trust estate. Their interests are property, and each therefore has power to transfer and convey her interest in the trust to the same extent that she could transfer her other property. Blair v. Commissioner of Internal Revenue, 300 U.S. 5, 1937. B. Transferee's rights. 442. A beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust res itself, but only of an equitable interest therein. Whatever conditions or limitations attached to the beneficiary's interest prior to the assignment apply against the assignee. Example: if beneficiary has a right to income for life and assigns it to friend, friend receives an interest for the life of beneficiary, not friend. If beneficiary dies, friend's right to income ceases. If friend predeceases beneficiary, friend's successors inherit the remaining right to income for beneficiary's life. C. Statutory modification of General Rule 443. In a few states, all trusts to receive and pay over the rents and profits from real estate, and sometimes expressly or by implication, from personalty to create inalienable interests in the beneficiary. Except that under most of these statutes, the beneficiary's creditors can attach amounts in excess of what is needed for the beneficiary's education, maintenance, and support. D. Antiquated exceptions. 444. By reason of antiquated future interest doctrines in a few states, it still appears that certain future interests, especially if classified as non-vested, are not freely alienable, a rule that applies to equitable as well as legal future interests. 2. Form and manner of voluntary transfer. 445. Generally, the equitable interests of trust beneficiaries may be transferred voluntarily by the same methods and formalities required for non-trust interests in the same type of property. A. Formalities. 446. If the trust estate consists of real property, a writing is generally required by the statute of frauds to transfer the interest. Again, this illustrates the concept that the beneficiary has an interest in the trust corpus. Ordinarily, no writing is required to transfer the beneficiary's present or future interest in a trust of personal property. Rest. 3D 53. B. Consideration. 447. No consideration is required to transfer an interest in a trust. As with other gifts, a gratuitous transfer is effective and in the absence of statute irrevocable. Rest. 3D 521. C. Delivery. 448. A few courts have taken the dubious position that there can be no delivery of an equitable interest and hence that delivery of the beneficial interest in a trust is not necessary. Other courts require delivery of a written deed of gift of the beneficiary's interest, or at least some form of symbolic delivery. Corridan v. Chandler, 108A, 296 NH, 1919. Thus, in those jurisdictions, even though the writing may not be required for statute of frauds purposes, because the trust consists of personal property see above, a writing or other symbol would still be needed for purposes of making delivery. D. Notice 449. Notice to the trustee is not necessary for an effective assignment, unless required by the trust instrument. Rest. 3D 51 CMT. D. 3. Rights as between successive assignees. A. Majority View 450. As between successive assignees of a beneficiary's interest, in most jurisdictions, the first in time prevails, irrespective of who first gives notice to the trustee obligor. Moorestown Trust Co. v. Busby, 157A, 663 NJ, 1932. Example: if beneficiary assigns his income interest to friend and 3 months later assigns the same interest to cousin, friend prevails. 1. Rationale: the beneficiary's interest is an equitable estate, and once transferred, there is nothing to transfer again. 2. Estoppel 451. General principles of estoppel apply. For example, where the first assignee fails to give notice to the trustee, and in good faith, the second assignee purchases the beneficiary's interest in reliance on the trustee's representation that he knew of no previous assignments, the first assignee may be estopped from asserting a claim to the interest. Rest. 3D 54. B. Minority View 452. In some jurisdictions, based on English precedent, the first assignee who gives notice of the assignment to the trustee prevails. 4. Creditors and other involuntary transfers 453. Subject to some extent to provisions of the trust, especially spendthrift restraints, infra 460. Beneficiaries' interests are governed by the same involuntary transfer rules as legal interests. A. Distribution on death 454. Thus, on the beneficiary's death, her interest, if not under the trust instrument, terminated by her death, as it usually would be, is subject to the same rules of descent and distribution or Will's law as a legal interest in the same property would be, including the elective share rights of a surviving spouse. Rest. 3D 55. B. Creditors' remedies 455. The creditors of a beneficiary can, by appropriate proceedings, reach the beneficiary's interest in the trust to satisfy their claims, except where the trust is spendthrift in nature. See infra 460. McKimmon v. Rogers, 56 NC, 201-857. Rest. 3D 56. 1. Creditors' bill in equity 456. At common law, a beneficiary's interest was not subject to execution in a strict sense. The usual procedure was, and in many states still is, to file a creditor's bill in equity or its equivalent, alleging no adequate remedy at law, i.e., that the judgment creditor had sued out a writ of execution which was returned unsatisfied. The equity court could then decree that the trust income otherwise payable to the beneficiary be paid to the judgment creditor to the extent required to satisfy the judgment. In many states, there would be no sale of the beneficiary's interest as such. In others, there could be a sale only if the court concluded that the creditor would not otherwise be paid off with interest within a reasonable period of time. As soon as the debt was paid off, assuming no sale, the beneficiary would again be entitled to the income. See, e.g., Barry v. Abbott, 100 Mass. 396 1868. 2. Direct execution 457. By statute in many states today, the creditor can execute directly on debt and sell the beneficiary's interest. In some of these states, however, creditors may not be allowed to reach contingent interests, where the forced sale of those interests would entail great sacrifice. In some states, the creditor's bill remains available as an alternative. 3. Res protected 458. In either case, the creditor can reach only the beneficiary's interest in the trust, not the trust property itself, unless the debtor is the sole beneficiary. B. Restraints on alienation, spendthrift, and related trusts. 1. In General 459. While it is generally recognized that beneficiaries are equitable owners of the trust res and that their interests are transferable, most states allow the beneficiary's interests to be conditioned or limited to prevent or impair transferability. 2. Spendthrift trusts 460. A spendthrift trust is one in which, by statute see supra, 443 or more often by virtue of the terms of the trust, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. This type of trust is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. Rest 3D 58. A. Form and Scope 461. No particular wording is necessary to create a spendthrift trust. It is sufficient if the words used show the settler's intent to limit the beneficiary's power to transfer his interest. Rest 3D 58 CMT 63. Example. The language, settler to trustee in trust for beneficiary, to be paid to beneficiary personally and to no other, whether claiming by beneficiary's authority or otherwise, creates a spendthrift trust. 1. Involuntary transfers 462. A spendthrift restraint may be written so that it applies to both voluntary and involuntary transfers. Sometimes, however, a restraint provides that it applies solely to voluntary transfers or solely to involuntary transfers. Would this be effective? On grounds of unfairness to creditors, there is doubt in most states that involuntary alienation can be restrained while allowing voluntary transfers, although some states do provide for this by decision or statute. There is also some doubt, based on concerns of impracticability, that voluntary transfers alone can be restrained. B. Distinguish conditional gift 463. A spendthrift provision restrains the beneficiary's right to transfer his interest or his creditor's rights to reach it. This trust is to be distinguished from a disposition that is conditioned on the beneficiary's financial status. Example. Father to trust co. Entrust to pay the property over to son if son ever becomes solvent and clear of debt. And if he never does, then on son's death, to daughter and her heirs, in such a trust, the gift to son is subject to a condition precedent, and unless and until son complies with the condition, his interest never vests. Because son could not insist on payment prior to fulfilling the condition, neither can son's creditors. Hull v. Farmers Loan and Trust Co. 245 U.S. 312 1917. Example. Similarly, a beneficiary's interest may be subject to a condition subsequent. Father to trustee in trust for son. But if son shall ever become bankrupt, then in trust for son's children. Here, the occurrence of the condition terminates the beneficiary's interest. Scott v. Ratliff, 200 W. 462 Chi. 1918. This is basically the rationale underlying protective trusts, see infra, 498. C. Validity of spendthrift restraints 464. Spendthrift provisions are held valid in nearly all American jurisdictions. Rest 3D 58 CMT. Where allowed, the restraints may be validly imposed on income interests, and a majority of the few decisions on point also allow such restraints on future interests in principle. See, e.g., Erickson v. Erickson, 266 NW. 161 Min. 1936. 1. Distinguish invalidity of restraints involving legal interests 465 Restraints on the alienation of legal interests are, in nearly all places and forms, void when repugnant to the interest created. See Property Summary. because such repugnancy is nearly always found to exist with respect to fee interests. This generally means that when dealing with such an interest, any restraint whatsoever, even one attempting to prevent creditors of the grantee from attaching, is void. And when dealing with life estates or terms of years, at most only reasonable restraints limited as to time and parties will be upheld. 2. Restraints on equitable interests, generally upheld. 466. Nevertheless, in the trust context, in which the beneficiary's interests are equitable, most American courts have upheld spendthrift restraints on income, and even on principal, regardless of the length or nature of the beneficiary's interest. L.N. Reestate of Vaught, 25 NY 2D 163 1969, upholding spendthrift provision as to vested remainder in trust. 3. Minority contra 467. In at least one jurisdiction, spendthrift restraints have been held invalid and contrary to public policy. See Athorn v. Athorn, 128 A2D 9 and 10 NH, 1957. This position follows the English view, which applied to spendthrift restraints the same rule that is applied to restraints on alienation of legal estates. They are repugnant to the estate created and are therefore void. Brandon v. Robinson, 18 Yes, 429 811. 4. Limiting statutes. 468. A number of states, such as New York and California, have statutes that limit the effectiveness of spendthrift restraints. A few statutes provide that creditors can reach an arbitrary percentage, e.g., 10% of trust distributions, or that creditors can reach income only or some portion thereof. CCR. McCorkle, Annotation, Validity of Spendthrift Trusts. 34 ALR 2D 1T335 1954. A more common restriction on spendthrift clauses allows only amounts needed for support to be insulated from creditors' claims. For example, creditors may be allowed to reach the beneficiary's interest if either right to payments exceeds the amounts needed for the beneficiary's support or education in his accustomed standard of living, and Roman II, the trustee is required to make distributions, i.e., the trust does not allow the trustee to accumulate the excess income. 5. Bankruptcy rule follows state law. 469. The Bankruptcy Code has long respected the beneficiary debtor's spendthrift protection as to interests that are validly inalienable both voluntarily and involuntarily under state law. See 11 U.S.C. 54 LC 2. Exam tip. Don't confuse the rule against restraints on alienation, see Property Summary, with restraints on alienation of a beneficiary's interest. The rule against restraints on alienation applies only to legal interests. Restraints on the alienation of equitable interests, e.g., spendthrift trusts, are generally upheld. D. Effective spendthrift restraints. 470. Where the spendthrift restraint is valid, generally no enforceable transfer is permitted. 1. Scope of restraint. 471. Where it is established that a restraint may be imposed against both voluntary and involuntary transfers, a court might not respect a restraint on involuntary alienation alone or on voluntary alienation alone. However, even where a court will not, it may construe a restraint that expressly refers only to involuntary transfers as one also intended, i.e., by implication to prohibit voluntary assignments. 2. Effect of attempted voluntary transfer. 472. Despite a valid spendthrift provision, if the beneficiary attempts to assign his trust interest to another, the assignee cannot enforce the assignment over the beneficiary's later objection, i.e., a purported assignment is, in effect, revocable. A. Trustee authorized to pay assignee. 473. The purported transfer, however, is not void. As long as it has not been retracted, it operates as a valid but revocable authorization for the trustee to pay, and for the assignee to receive the payments to which the assignor would have been entitled. The trustee is protected if she makes payment to the assignee in reliance on the purported assignment. B. Beneficiary may revoke authorization. 474. Once the assignment is revoked, however, the trustee must pay the beneficiary alone. Failure to obey the beneficiary's direction to cease payments to the assignee will make the trustee liable. In this case, the assignee would have no rights at all against the trust or the beneficiary's interest. But if the assignee paid consideration for the assignment, he would be entitled to restitution, payable from the beneficiary's other assets. Kelly v. Kelly, 11 Cal. 2D 356 1938. Exam tip. It is important to remember that an attempted assignment in violation of a spendthrift provision is not void. Although the assignee cannot compel the trustee to pay because the assignee does not acquire the beneficial interest, the trustee is authorized to pay the assignee as long as the beneficiary does not revoke the trustee's authority. If the assignee gave value for the assignment and the beneficiary revokes the assignment and the trustee's authority pursuant to it, the beneficiary is liable to the assignee. Although the assignee cannot reach the trust property, the claim can be satisfied from the beneficiary's other property or from trust funds after they have been distributed to the beneficiary. See infra 476. 3. Creditors' rights and actions 475. If there is a valid spendthrift provision in effect, creditors are generally barred from reaching, i.e., attaching and selling or taking the beneficiary's interest in the trust. Commonwealth v. Burfield, 51A2D 523 Pa. 1947. Thus, it is said, a creditor cannot, just as an assignee cannot, anticipate the beneficiary's rights. A. Distributions from trust, not protected 476. However, once the monies are paid to the beneficiary from the trust, they are no longer protected. The beneficiary's creditors may attach and execute thereon, just as they could on any other asset of the beneficiary. Brossamer v. Mark, 540 NE2D 652 int. 1989. Commonwealth v. Burfield, Supra. B. Exceptions. Certain creditors can break through spendthrift restraints 477. Even where spendthrift restraints are otherwise held valid, certain classes of creditors can break through and reach the beneficiary's interest in most states. 1. Classes of creditors 478. The third restatement provides that the spendthrift restraint is not effective against the following types of creditors. I. The federal or state government, e.g., tax claims, to the extent provided by federal law or an applicable state statute. Roman 2. A spouse or ex-spouse or child for support. Roman 3. One who without being officious furnishes necessaries of life to the beneficiary. And Roman 4. One who in some way preserves the interest of the beneficiary, e.g., legal counsel. Rest. 3D 59 and CMT. A1. 2. Split of authority 479. Cases generally support most of the exceptions above in most states, but the case authority is in conflict on other than governmental claims. A. Spouse 480. A number of states have held that the spouse or ex-spouse, and a few have held that children of the beneficiary of a spendthrift trust cannot reach his interest for the satisfaction of their support judgments. In Re-Estate of Johnston, 252 Cal. App. 2D 923 1967. Dependent child, no better off than any other creditor. Erickson v. Erickson, Supra, 464. But see trend reflected in Cal. Prob. Code 15E 306 UTC 503. And see Counsel v. Owens, 770 SW2D 193 ARC. 1989. B. Necessaries 481. There are also cases holding that claims for necessaries furnished to the beneficiary cannot be enforced against his interest in a spendthrift trust. Riley v. State, 177A, 528 Con. 1935. But see in Re-Estate of Dodge, 281 NW2D 447 Iowa 1979. Recovery is more likely if the state is the party seeking reimbursement for, e.g., institutional care of the beneficiary. Estate of Lackanan, 156 Cal. App. 2D 674 1958. The UTC does not recognize an exception for necessaries. although it does include services to protect a beneficiary's interest in its list of exceptions. UTC 503. C. Tort Claims 482. A few states may allow tort creditors to reach a beneficiary's interest in a spendthrift trust, especially where the beneficiary's acts were intentional or grossly negligent. CGA, Code Ann. 531228. Slig v. First National Bank, 704 so. 2D 1E20 Miss. 1997 overturned by Miss. Code Ann. 919503. And C. Charles D. Fox, Roman 4 and Rosalie Murphy. Are spendthrift trusts vulnerable to a beneficiary's tort creditors? 137 TR. And EST. 57 1998. Spendthrift protection. By the federal or state government, to the extent provided by law. For support of a child, spouse, or ex-spouse. For services or supplies provided for necessaries. For services or supplies provided for the protection of the beneficiary's interest in the trust. E. Spendthrift clause cannot protect retained interest of settlor 483. The rule is clear and well settled that the owner of property cannot create a spendthrift trust for himself, i.e., the settlor is not permitted to put his own property beyond the reach of his creditors, present or potential, to the extent of his retained interests therein. Johnson v. Commercial Bank, Supra, 123. The interests retained by the settlor would be reachable by his creditors, although the interests conferred on others are not, unless, of course, the transfer itself was a fraudulent conveyance, e.g., as it may be Roman 2, the settlor had been insolvent at the time of the transfer, etc. McColgan v. Walter Maggi, Inc., 172 Cal. 182 1916. 1. Circumstances in which beneficiary is settlor 484. The rule that a property owner cannot create a spendthrift trust for himself applies to any transfer, direct or indirect, whereby he attempts to put his property beyond the reach of his creditors. Rest. 3D 58 CMT. F. Example. Settlor pays $500,000 to friend, for which friend conveys Blackacre, not to settlor directly, but to trustee and trust to pay the income to settlor during his lifetime, and then to convey title to settlor's issue on his death. Settlor has indirectly created the trust, and any spendthrift restraint on his interest, i.e., here, as life income beneficiary, would be invalid. The remainder in settlor's issue, however, is not tainted and is safe from the creditors of settlor, as well as those of settlor's issue. Exam tip. Of course, you should remember the rule that the settlor cannot create a spendthrift trust to protect his own property from his creditors. However, you may encounter a fact pattern in which it is not obvious that is what the settlor is attempting to do. The settlor may be disguised as a beneficiary, as in the example above. When you are trying to determine whether a beneficiary is the settlor, look to see who furnished the consideration for the creation of the trust. If a person furnishes the consideration, he is likely the settlor, even though the trust is created by another person. 2. Spouse beneficiary, who elects against Trust 485. The fact that the settlor's surviving spouse is a beneficiary and declined to exercise a right to reject the testamentary trust and take a statutory share of the settlor's estate does not make the spouse a settlor by purchase, so as to allow her creditors to reach her trust interest according to present case law. But compare Medicare eligibility cases. Example. Husbands will left property in spendthrift trust for wife. Wife had a statutory right to elect against husband's will and receive 1/3 of the assets. Wife chose instead to take under the will. Her creditors cannot reach the trust estate or her interest in the spendthrift trust. She is not deemed to have become setter of the trust for purposes of the rules see above that a person cannot create an effective spendthrift trust for herself. American Security and Trust Co. v. Utley, 382 F2D 451 DC. Sir. 1967. F. Arguments for and against spendthrift trusts. 1. Arguments against 486. There are two basic grounds on which the validity of spendthrift trusts is usually attacked. A. Symmetry of estates 487. There is no reason to treat equitable estates differently from legal estates. Because the beneficiary's interest is generally conceded to be an equitable ownership of the trust res C supra. 217-222. Any restraint on ownership should therefore be deemed to be repugnant to the interest created. B. Social Policy 488. A creditor should be able to reach the assets of the debtor on the same basis and with the same exceptions, whether the assets are held in trust for him or not. Hence, there is no social justification for upholding a spendthrift provision allowing the creditor to go wanting, while the debtor enjoys the benefits of wealth without need of financially responsible behavior. Statutes specify the exemptions allowable for insolvent debtors. Settlers should not be allowed to create additional, private exemptions for their trust beneficiaries. 2. Argument for 489. The only real argument to support spendthrift trusts is based on an owner's freedom of disposition. The donee, and thus his creditor, has no right to the property, which the settler was free to withhold. Therefore, with respect to interests he chooses to give to the donee, the wishes of the donor-settler should be given effect. It does not violate any principles of sound public policy to permit a testator to give to the object of his bounty such a qualified interest in the income of a trust fund, and thus provide against the improvidence or misfortune of the beneficiary. Broadway National Bank v. Adams, 133 Mass. 171-882. 3. Discretionary Trusts 490. A discretionary trust is one in which the trustee is given discretion to make or apply or withhold distributions of income or principal or both to or for one or more beneficiaries, whether or not the instrument provides standards for the trustee's guidance, but see infra 501. Rest. 3D 50. A. Beneficiaries' rights cannot be anticipated 491. Before the trustee exercises her discretion to make payments to the beneficiary, it has generally been held that the beneficiary's interest cannot be reached by his creditors. Hamilton v. Drogo, 241 NY, 401 1926. 1. Rationale. Courts have often reasoned that because the beneficiary cannot force the trustee to pay anything, although rarely is this true, there is nothing substantial for the creditors to reach by execution sale or to demand from the trustee. Kittner v. Kittner, 171 NW, 590 Iowa 1919. A. Public Benefits 492. If a beneficiary of a discretionary trust applies for benefits under a need-based state or federal program, it remains uncertain whether this reasoning is effective when the public agency seeks to withhold benefits because the applicant has independent resources, or when the public agency seeks to compel the trustee to satisfy a statutory claim for care and services provided to the beneficiary of such a trust. The trust language, such as carefully drawn language in a special needs trust, can be helpful, and the trend of decisions and recent legislation appears to be unfavorable to the public agencies. See e.g. NY, EST, Powers and Trusts Law 7112. In Re Roberts, 61 NY 2D 782 1984. 2. Circumventing limitations on spendthrift protection 493. The discretionary trust is a much-used device, not only in jurisdictions that do not recognize or significantly restrict spendthrift trusts, but also to avoid mandatory payments that creditors could reach after distribution. See Supra, 476, and C Infra, 498. B. Trustee's decision to pay 494. If the trustee decides to pay over or to apply some amount of trust income or principal to the beneficiary, the right to that amount matures in the beneficiary, and his creditors or assignees may then reach it. Canfield v. Security First National Bank, 13 Cal. 2D 1 1939. 1. Creditors may attach, but not compel distribution 495. In fact, by the better view, creditors are allowed to attach the beneficiary's interest, but usually may not compel the trustee to make distributions. 2. Judicial protection from abuse of discretion 496. Some courts have recognized the flaws in the foregoing analyses. A discretionary beneficiary can obtain a remedy for a trustee's abuse of discretion, even, although not so readily, if the trustee is purportedly granted absolute discretion. What constitutes an abuse depends on the terms of the discretion, especially the standards in the instrument and the degree to which those standards are objective. Rest. 3D50. Some courts allow creditors to compel payments if the beneficiary could do so. 3. Trustee liable for missed delivery 497. Once notified of an assignment or attachment of the beneficiary's interest, the trustee will become personally liable to the assignee or creditor if she distributes funds directly to the beneficiary, unless a valid spendthrift restraint is also involved. Rest. 3D60 CMT. B. Exam tip. If you encounter a discretionary trust on your exam, remember that before the trustee exercises his discretion to make payments to the beneficiary's interest cannot be reached by her creditors, although a more precise common law analysis might allow creditors to compel proper exercise of the discretionary power if the trustee has abused the discretion. But after the trustee exercises his discretion and elects to make payments to the beneficiary, the trustee must make those payments not to the beneficiary, but directly to her creditors, if the trustee has notice of an assignment or attachment by the creditors, unless the beneficiary's interest is protected by a spendthrift restraint. 4. Protective trusts 498. A protective trust has long been used in England and is increasingly used in American jurisdictions. See Supra. 493. A protective trust usually is an ordinary trust that pays out its income regularly, but which, upon an attempted voluntary or involuntary alienation of the beneficiary's interest, becomes a discretionary trust, sometimes a broad one to apply the income for the benefit of any or all of a group that includes the original beneficiary. See Infra. 500. Duncan v. Elkins, 45A2D 297 NH, 1946. Example. Settler to trustee and trust to pay income to child for life. But if child ever becomes insolvent or creditors attempt to reach his interest in the trust, or if child attempts to assign his interest, then to pay such amounts as trustee deems appropriate to, or for the benefit of child or his wife, his issue, or his brothers or sisters. A. Rationale. A protective trust may be intended to reach a result somewhat comparable to, and in fact more secure than the result of a spendthrift trust. But it is logically less objectionable in that the beneficiary can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. On the other hand, these trusts are subject to the criticism that they accomplish indirectly what they could not do directly in some states. The Bankruptcy Code 11 U.S.C. 541 CLB no longer accepts the intended result of protective trusts. 5. Support Trusts 499. A support trust is one in which the trustee is directed to make distributions or applications as necessary for the education and maintenance of the beneficiary, and to expend the income and principal only for that purpose. Rest. 2D 154. Support trusts, in one form or another, are quite common for a variety of reasons, e.g., tax advantages, flexibility in providing for beneficiaries, support of minors, etc., and are sometimes used where spendthrift trusts are not recognized or are significantly limited in their effectiveness. See Supra. 468. A. Result and rationale. When courts that purport to follow this rule are able to find that the interest of the beneficiary is a support interest, which case law reveals is often difficult to do, the interest is held not to be assignable or reachable by creditors. This is due to the nature of the beneficiary's interest, and not to any direct prohibition against voluntary or involuntary alienation. The trust is said to be personal to the beneficiary and thus restricted, in that payment to a transferee or creditor would not accomplish the permissible trust purpose, the support of the beneficiary. In Re Keeler's estate, 3A2D 413 Pa. 1939. Is this not true of any trust, such as one for the benefit of the beneficiary? It is not surprising that some courts have simply rejected this concept, perhaps finding it hard to say that the interest cannot be enforced. 6. Blended trusts 500. If a trust is for the benefit of a group of persons and no member of the group has an interest separate and apart from the others, it is sometimes called a blended trust, i.e., each beneficiary's interest is said to be inseparable from or blended with that of every other beneficiary. Tolley v. Ferguson, 62 SE, 456 W. The 1908. A. Effect. Under such a trust, it has been held that no member of the beneficiary group has an alienable interest or one that his creditors can reach. Example: settler transfers to trustee upon trust for daughter and the members of her family. Courts will generally hold that the beneficiary's interests are inseparable and inalienable, but it is possible to argue that the gift was intended for daughter only, i.e., that she alone is the beneficiary, and that providing for her family is merely an expression of motive. Much as a provision for the beneficiary's support is usually construed to include amounts needed to maintain the beneficiary's accustomed family lifestyle. 7. Distinction between discretionary, support, and blended trusts questioned 501. In practice, most trusts that grant trustees discretion to make distributions and determine their amounts, or to withhold distributions, contain standards, usually related to support, but often with added language, e.g., general welfare. These beneficial interests, whatever the drafting details, are as personal in one form as in another, and in fact are enforceable, although to varying degrees, to prevent fiduciary abuse. Accordingly, the above distinctions are widely recognized today as artificial and are clearly a source of unjustifiable and litigation, causing differences in treatment among persons who are similarly situated. Thus, the distinctions among these various forms of trust are rejected in the Third Restatement and the Eti. Rest. 3D 50, 60 and 60 Reporters' Notes on CMT. A. and CUTC 504 CMT.